Good afternoon, everyone. Welcome to today's webinar, Addressing Heirs Property for Forest Landowners. I'm Karen Zilliox Brown. I'm with the Longleaf Alliance, and I'm joined today by Skipper StipeMaas and Jasmine Helms from the Georgia Heirs Property Law Center, and also Jacob Barrett from the Longleaf Alliance. We're happy to have you all joining us today and taking a little bit of time out of your lunch break to learn about this subject. This talk will highlight some common scenarios in which heirs property is created, share some knowledge that landowners anywhere can use to prevent the creation of heirs property and preserve the value of their family forest or farm, and inform you about the resources and tools available to Georgia landowners specifically to plan for the future transfer of their land. All of this is an effort to increase opportunities for Georgia forest landowners, resolve their heirs property issues, and really unlock the value in their land. That's done primarily and first and foremost through having clear title and clear access to their property. To guide us through this topic, we're very fortunate to have Skipper and Jasmine, two professionals who work with heirs property issues day in and day out from the Georgia Heirs Property Law Center. Skipper is the executive director of the center, and Jasmine is the outreach and partnerships coordinator. I'll let you both of you ladies introduce yourselves a little bit further. I just want to get through a couple of webinar kind of housekeeping reminders before we jump into it. We'd love to take all of your questions, so please use that dedicated Q&A tab function on the toolbar on your screen to type those in throughout the talk. We'll address them towards the end of the session today. Jacob is going to be monitoring that Q&A area and helping to funnel those through when we have some time at the end of the prepared talk. If you'd like to introduce yourself, though, use the chat function. Just let us know where you're coming to us from. It's great to see who's on the call and see some familiar faces. This session is being recorded, so it will be made available for later viewing. That takes about a week to get that back up on the forestry webinar portal where you began today's webinar. So just keep a lookout for that. We'd be happy to have you share that with anyone who might have missed it today. So Skipper and Jasmine, it'd be great to have you take over the screen controls at this point, and maybe take a moment to introduce yourselves and your roles at the center just a bit further before starting the presentation. And Skipper, you're still muted.
Yes. Okay, Jasmine, I'm going to let you introduce yourself first since you're the second speaker, because once I start talking, I'll just go.
Sure. So I'm Jasmine Helms. I'm the Outreach and Partnerships Coordinator for the center. Gosh, I guess it's been over a year that I've been in this position, and it's been pretty exciting to help landowners throughout Georgia with kind of educating them on heirs property and the benefits of having an estate plan to prevent heirs property. So it's great to see so many participants today. It's exciting.
Thank you, Jasmine. It feels like it's been much more than a year because you interned with us for it seems like several years, but Jasmine's amazing. It's great to have her on the team. I am Skipper StipeMaas. I am an attorney, and I was born and raised in South Georgia on a farm about 3 miles from Florida, just south of Dixie, Georgia. The title of this, Don't Spend Your Pines, is from my childhood experience of listening to people talk about how to manage their pines, and that you didn't want to get into so much financial crunch that you had to harvest your pines before they would get the top dollar. And so as you so heirs property in Georgia is really important, and it's been a lifelong process for me to unravel it and to figure out exactly how to deal with it. And the center is now in its 9th year, and we're chugging along. So with that, we'll go ahead and get started. So we are a nonprofit law firm, and like any good law firm that's doing educational outreach, we have to give a disclaimer that none of this is legal advice, is for education purposes only. So one of the more interesting thing about heirs property is the diversity of the funding, and it impacts everyone. It impacts every sector. And so we have banks involved, the Longleaf Alliance, agriculture, and many different folks from different sectors of the funding. Our roadmap today is to introduce you to the center, talk about heirs property and why it's a problem, how it impedes resilience and generational wealth building, and then myths and facts about heirs property, and identifying and resolving heirs property, and then the estate plan for timber and ag land, and then we'll have wrap up and questions. So let's jump into the center. The center was started in 2015. And the mission is to build generational wealth, economic value, and community stability by securing and preserving property rights. Our attorneys and support staff work throughout the state, and we partner with nonprofits, governmental partners, pro bono volunteers, and the folks that are impacted by the institutions that are impacted by heirs property. Our geographic focus and outreach is in Atlanta and South Georgia, but over time what we have found is we've really had to narrow in on where we have funding to work and on the place-based funding, because the need is so great in Georgia that we really have to make sure that we have the funding in order to serve. Heirs property is home or land that has been passed from generation to generation in such a way that multiple people own the same piece of property. The deed is typically in the name of a deceased relative, and which results in fractured or tangled title shared among multiple family members that are the heirs to that deceased relative. So what does the center do? We work in 3 buckets. The first is we clear title or consolidate title, get the title so that it's in present day living people's names, are ideally in one person's name. We provide the legal support to do that to families, individuals, nonprofits, and local government. We do the title searches and the title audits. We apply about 5 different legal strategies to resolve titles. The second bucket is land loss prevention, or heirs property prevention, which is also known as estate planning, but estate planning with the next step of really looking at wills that do not create heirs property accidentally. Just having a will isn't enough to prevent heirs property. If you leave your home or your land to your 4 children, you have effectively created heirs property. So some of that estate planning is also outreach and education to attorneys, so that attorneys start recognizing what they're doing in their estate planning process and being a little more intentional. And then the last bucket is asset education, and that means helping folks understand the value of what they own and how to grow it as an economic resource, whether that's a home or land or forest or farming. We try to connect them with the right resources so that they can increase the value of what they have. Since 2015, we have closed over 1,000 matters. We've unlocked $10.8 million in equity and protected $21.9 million in equity. And those numbers are based on the tax appraised value. So they're probably a little bit low. We've delivered over 400 community outreach programs in 119 of Georgia's 159 counties, and that's outreach to over 15,000 people. We currently have 128 open matters 113 of those are clearing and title review matters with a tax appraised value of 9.3 million, and we have 15 estate planning matters that are open. So here we are on the map. The yellow stars indicate offices throughout the state, and the red shows where we have heirs property cases, and the green is where we've done Landowner Academy, and the purple is where we've done an all-day clinic to address estate planning. So how much heirs property is in Georgia, and who does it impact? It impacts local governments, nonprofits, private sector, researchers and public outreach, state and federal agencies, legal community, but yet we all have those shared goals that bring us together. In 2023, the center, in partnership with NASA Develop, used satellite and tax data to identify probable heirs property in rural counties impacted by 2017 Hurricane Irma. And through that study, we discovered that there's $47 billion in frozen equity, also known as heirs property, in the state of Georgia. So heirs property undermines every aspect of our economy and our communities. So we've also, numbers are important to show sort of the impact and why it is that we need to be doing this work. And we have found that for every dollar invested in the center, we've been able to unlock $14 of equity. And for estate planning, for every dollar invested in the center's estate planning services, we've protected $24 worth of equity. So what is heirs property and why is it a problem? It's a home or land that's been passed from generation to generation. As I said before, the recorded deed is typically in the name of the deceased relative, and it results in fractured, tangled title, grandpa's land, a family land. There are lots of terms that are used to describe it. It happens when an owner dies with a will, leaving the property or the home to multiple individuals, or when the owner dies without a will, so the property passes to heirs at law via intestate succession. That's a mouthful. So I love these. These are actual real cases. And here's an example. Mom owns a home and dies without a will. She is survived by dad and 4 children. The real property is co-owned by 5 heirs now. One of the myths out there is that if you die in Georgia and you have a spouse, that your spouse will immediately inherit everything if you don't have a will. But that is not true. As demonstrated here, it would go to the spouse and the 4 children. So Ann and Bill, if we build on that example, Ann and Bill die before mom, both without, both without wills. Mom dies without a will, survived by dad, Carl, and Diane. Ann's share goes to her 3 children, and Bill's share goes to his child. The real property is co-owned by 7 heirs now. So this is example 2.1. Carl dies without a will. His share goes to his spouse. Then Diane dies without a will. Her share goes to her spouse and children. The real property is now co-owned by 9 heirs, including in-laws. So this is actually based on real cases that we've handled. So this is not a made-up scenario. Okay, we're on to the next one, right?
Mm-hmm.
Okay, Carl's wife, Kathy, remarries Earl. Kathy dies without a will. Her share, which she inherited from Carl, goes to Earl. Then Earl dies without a will. His share, which he inherited from Kathy, goes to his children. The real property is now co-owned by 10 heirs, including in-laws and non-family members. So 2.3, it turns out that dad had a child, Gail, outside of his marriage to mom. Dad was predeceased by Anne, Bill, Mom, Carl, and Diane. Dad dies without a will. Dad's share goes to Anne's 3 children, Bill's child, Diane's children, and Gail. The real property is now owned by Dad's 7 heirs and Mom's 9 heirs. As you can see, it gets more and more complicated, and a situation like Gail is not unusual. Excuse me just a moment. How heirs property impedes resilience and generational wealth building. So what does it mean to own heirs property? If you're an heir, you're a tenant in common, and each heir has equal rights to full use and possession of the real property. Each heir is legally responsible for taxes and other real property related expenses. Each heir may transfer interest in the real property to another heir or outsider so they can sell their portion. So suddenly you could be owning the property with someone you've never met before and don't know. Each heir may seek a partition of the real property, and each heir must agree to any major decisions about the real property. So why is it a problem? It increases family disputes. Otherwise, rational family members act unreasonably. Family relationships can be permanently ruined. You lose a connection to home, farm, timberland, family, and community, and you lose the sense of independence associated with home or land ownership. So how does it impact communities? Heirs property, especially after a natural disaster, often becomes abandoned and blighted property, which reduces the county's tax base. Status makes it difficult for cities to identify owners, enforce code ordinances, and collect property taxes. As a matter of fact, some of our referrals are actually from code enforcement because they know that because of the entanglement of the title that the property is not being taken care of. It's a contributing factor to the decrease in owner-occupied homes and family-owned farms, and it hinders the efforts to increase affordable housing and family stability. And communities can lose funding for revitalization efforts if heirs property is pervasive. We've had communities that got federal funding and had to return it because they weren't able to work on the homes that they were planning to because they were heirs property. So why is it a problem for farmers and forest landowners? Individuals living on heirs property face an increased risk of forced sale and eviction that ties back to the comment I made a few minutes ago about the fact that any heir can file a partition, which means a division of the property. Heirs cannot sell, mortgage, or lease the property without agreement of all heirs. You have more difficulty farming, qualifying for agriculture loans, and selling agriculture products. You can't qualify for most rehab programs or secure financing for needed repairs for heirs property. You may not be able to participate in government programs offered by USDA, HUD, FEMA, and other federal and state agencies. And you can't qualify for loan modifications and other loss mitigation programs when facing foreclosures. You may not be able to qualify for conservation use tax reductions, homestead exemptions, or other property tax exemptions. It's just really hard to manage land with a whole bunch of people. Heirs property impedes timber sales. Clear title enables you to participate in programs, sell timber legally for the best price, and use best practices to manage and preserve woods and timber. For example, if an heir, also known as tenant in common, sells timber without a legal agreement with all the heirs, all the rest of the tenants in common, then the heirs selling the timber will most likely get a lower price and could be accused of stealing timber and asset from the other heirs unless they, yeah, it's complicated. I'm not going to go further. Also, interestingly enough, the USDA Forest Service in 2019 did a study and found that the tender on heirs property around national properties helped spread wildfires more quickly. So heirs property prevents and is a huge obstacle for generational wealth, because when you have clear title, you can open a line of credit or a mortgage. You can use real property as collateral for a loan. You can generate income by leasing the home to renters or the real property for farming or hunting or selling your timber. You can generate income through forest products by farming or selling natural resources on the real property. You can sell the real property, and you can pass the real property on to your family. Heirs property is the problem. Clear title is the solution. So we have some client stories about different clients that we've worked with who have cleared their title in order to manage and preserve their woods and land. Heirs spanning 2 generations manage the timber on their heirs' property for the benefit of all the heirs, and they actually use the funds from that management in order to clear their title and pay for some of the survey and cost associated with clearing the title. 6 heirs cleared title in order to close the USDA conservation easement, which reduced the farm debt and created economic sustainability. And that was a wetlands conservation easement. So it not only helped out the heirs and the farm that they were managing, but it also preserved more natural area. Protecting farmland from developers. This client, a developer had obtained 40% interest and wanted the entire piece of property, the 100 acres, and he filed a partition action, and our attorney was able to use a piece of the law in order to make it so that our client could actually buy out the developer, not the developer's wish, but what it is that the legal right was. So protected that 100-acre farm. With that, I'm going to turn it over to Jasmine.
Awesome. Thank you, Skipper. Yeah, so I'm going to talk about the myths and facts surrounding heirs property. And I think this is an important topic to kind of go through so that we can understand heirs property a little bit more fully and just talk about, you know, there's some commonly held beliefs that kind of make heirs property worse. So I'm going to go through a few different batches of myths and facts. And so the first one is about heirs property being a statewide issue. And the first myth in this batch of myths is that heirs property is only found in one area of Georgia. The truth is, heirs property is all over the state. It's all over the country. It can be found in rural and urban Georgia. It includes houses. It includes forests, farms. It even includes commercial properties. People don't think it would, but it does. And then, you know, kind of part of that, the second myth is that heirs property only has negative consequences for the owners of it and not for, you know, me or my community. But the truth is it impacts all levels of community. It causes blight, and that decreases a neighborhood's stability, reduces housing values, depresses the tax base. It prevents banks from making loans, and insurance companies can't issue policies. It does impact everyone. It might not be something you can see. Blight is something you can see. It's usually kind of, you know, houses that are a little bit more run down or have blue tarps or different things like that. But the rest of it you might not see, or you'll see it on your tax statements. And then also related to that is the myth that heirs property is a family problem, and that family is they're the only people who are responsible for solving it. But again, it kind of takes a village. So there are, a lot of different people with a lot of different skill sets who have to become involved. Obviously, there are attorneys, but then there are also genealogists who have to track down, living and deceased heirs. There are elected officials, government employees, nonprofit folks, and bankers, and tons of other people who end up having to get involved. So for the access, sale, and eviction portion, there are three main myths. The first is that it's not important to clear title to heirs property because heirs property status protects the property by preventing it from being sold. I mean, heirs property does complicate a lot of things, but it does not, it doesn't protect property. Basically, marketable title is necessary to protect and manage property, especially because individual heirs' interests can be sold. And that makes the property vulnerable to those forced sales, kind of like what that developer was doing back in the client stories. So any family or non-family member who owns just an interest in the property can sneak in and force a sale, and you can lose, a generation's worth of land like that. And so then the second myth in this section is that an heir can't sell his or her interests without the consent of the other heirs. And the fact is, an heir, again, you can do it. If it's specifically the interest in the property, anyone can sell it, and they don't need the consent of any others. And then the third myth is that an heir can change the locks or restrict other heirs' access to heirs' property. Again, like if you'll think back to the slide that Skipper talked about, where heirs' property owners are tenants in common. So that means that they all have an equal legal right to use and possess the property. So, you might be the heir living on there, but that doesn't mean that you can lock other people out or, tell them not to come on your property or different things like that. So everybody has a legal right. And then the property tax and tax sales section, this first myth kind of relates back to the last myth that I was just talking about. And it's that co-tenants who pay property taxes have a greater ownership interest in the real property than other non-paying co-tenants. That's not true. Again, it's about your legal right. So paying any current or back taxes, or even really spending money on any kind of maintenance, even if it's like lawn maintenance or something like that, that doesn't mean that you have any more of a legal interest in the property than anyone else. It might feel like it. You probably have more of a sentimental interest, but not a legal interest. And so that's kind of one of the things that we have to remind people of a lot, because they'll come in and say, look, I've done all this work for the property. I've tried to hold it together, and that it doesn't count for much legally, unfortunately. And so there's two myths on this one. And the second one is about tax sales. And so that myth is that title problems can be cleared by letting heirs property go to tax sale. The short answer is that if the property was heirs property before the non-judicial tax sale, it's still heirs property after that sale. And that title just remains clouded until the heirs property issues are created. And there's kind of the longer answer is that if it goes to that non-judicial tax sale, it can be redeemed within 12 months, but only by paying 120% of the purchase price plus interest. Third-party buyers, what they usually do is bid $10,000 or more of over past due taxes, and that increases the amount received upon redemption. And it can make it financially difficult for heirs to redeem the real property because, not everybody has that kind of money just lying around. And then also, redemption only returns the property to the status that it was prior to the tax sale. And basically, that means that the winning bidder has to wait out a 12-month redemption period and then still hire an attorney to foreclose or bar the right of redemption. And that still requires identifying all the heirs, providing them notice, and, and that's anybody who has an interest in the property. And then after all of that, you still have to clear the title. So it's a really lengthy process that does not solve all of your problems. And then the final batch of myths and facts is that, so the first one is about timber sales and pine straw sales. Basically, a lot of people think that you don't need clear title to sell timber or pine straw from property, but the fact is, one heir might be able to sell the timber, but they might not receive the highest price possible. I know, a few months ago, we had somebody come in who was saying, yeah, well, I mean, we were trying to sell timber from the property, but the buyer found out that it was heirs property and actually told us they're not going to give us as good of a price because it's heirs property. And so, like a lot of people run into that difficulty, even if all the heirs are on board. But if it's just one heir who's selling it, that one heir needs to make sure that the proceeds of the timber sale or pine straw are split between all the heirs. And if they're, if not everybody gets it, or if there's a missing heir, it needs to be held in escrow. But a lot of times that doesn't happen. Some people might just sell and take the money. And that's basically opening themselves up to legal problems because the other heirs can come after them and, demand their share of the profits. And then the last myth is that you don't need clear title to participate in USDA programs. So I will say, last weekend, I attended the Marion County Forestry and Wildlife Expo with Karen and Jacob. They were awesome booth buddies, I would say. But one of the things that I kept running into with people was that they didn't know what heirs property was, but they did know that, their parents had clear title and their parents were able to work the land and, get involved in whatever forestry and ag programs they wanted to. But once their parents died and the property went into heirs property, all of a sudden they couldn't do anything. They couldn't do the stuff that they wanted to do. And so, basically when funds are involved in these different USDA programs, whether it's cost sharing or conservation programs, loans, clear title is required to keep operating. And so that's a pretty big one that I think a decent amount of farmers might understand, but it's still something that, people don't really know that it's heirs property causing it for sure. And so identifying heirs property, there are a few different signs that we look for, identifying and resolving, which we'll get to some of the resolving stuff as well. But so there are some signs of heirs property that we kind of try to make obvious to people, which is, the first one is that the deed is in a deceased relative's name. Oftentimes, not all the time, but oftentimes, if it's in a grandparent's name, like a great grandmother's name, there's usually, and you can't find any other more recent chain of title, it's usually heirs property. And then also similar to what I was talking about previously, if a landowner can't sell products, ag products, forestry products, or anything, and has to take any extra steps to apply for a farm services number, they typically have an heirs property issue that's barring them from doing what they want to do. And then also this third one also kind of goes back to some of the things I was mentioning about, people's legal responsibilities. Usually they're, technically supposed to pay taxes. Everybody is. And so, if you have somebody who's saying, oh, so-and-so is not paying their share of the taxes or the maintenance, that usually means that, there are multiple owners and all of them have a responsibility to the property and somebody is just not holding up their end of the deal. It's also important to kind of reassure people that heirs property isn't anything to be ashamed of. A lot of people have it in their family. I will say I have it in my family, and I mean, I think people have learned from it because I've heard about more people getting estate plans and stuff like that, and I've probably harped on them enough. But, you know, it's amazing how quickly once somebody dies and there's property available that people just start, you know, like it fractionates out, people start fighting, there's a lot of issues. And I can say, you know, I mean, Skipper having it in her family is one of the reasons why this organization exists, and resolving it is one of the huge things. And so, you know, succession planning is a big part of figuring out how to solve it and prevent it. And so just a quick thing about succession planning, it's a really helpful way to explore personal decisions in a business sort of context. I mean, really, you're managing your farm and your land is a business operation, as many of you probably know. And so you kind of have to encourage people to ask themselves, you know, how do you want your land managed after you pass away? Do you want it to support the family? Do you want it to be for profit? Do you want conservation, recreation? I know when I talk to people, a lot of people want, you know, they want the next generation to be involved and they want clear title to kind of continue after them. And then you also want them to kind of encourage, kind of share their goals and hopes with potential heirs and engage them in the current management of the land. And then also kind of encourage landowners to work with an attorney. Again, a well-done estate plan can help you lay the roadmap for other heirs to follow behind you and kind of figure out, you know, like, okay, we have this trusted attorney that we can go to, and, you know, everybody that comes after me can kind of, you know, keep those good habits of getting a good estate plan and making sure that everything is managed properly. And then also we kind of have to reassure people that you don't need to cut anyone out of your will just to prevent heirs property. The right attorney can help explore other options. You know, there are LLCs, there are trusts, but there are also, you know, other legal mechanisms that can allow heirs to keep the property in the family. And that's one of the great things, at least that I've noticed about working with, you know, more rural folks, is that a lot of people are trying to keep it in the family. And so, you know, they want everybody invested and they want that land in everyone's name. And so, you know, there are different ways to manage it collectively without creating heirs property. And so how do we help individuals with heirs property? Basically, we consult with families on the status of their property and explore solutions for securing clear marketable title. You know, that usually means having sometimes it means having a whole family meeting about what everybody wants, but, you know, each family is different. Sometimes, I mean, there are big families, there are small families. Sometimes it's actually the big families that really collaborate well and, you know, are all willing to quit claim their interest to one heir so that that person who's living on the property can have it. But sometimes you might just have 4 heirs and they all don't agree. And so it's just one of those things where you really have to figure out, you know, what's the goal for the property and what will work best for these individuals and these clients. And then once we kind of figure that out, then we provide the direct legal representation to help unlock the value in the heirs property. And that means identifying all the heirs and their percentages of ownership, determining the steps needed to address the case, probate any deceased relatives' estates, prepare affidavits of descent and any other legal instruments, negotiate consolidated forms of ownership, every once in a while, you know, partition or quiet title action. And then we also try to help clients understand that it literally, I mean, it'll take generations sometimes to create a mess of heirs property, and it can take a long time to fix it. Usually not as long as it took to create it, but still, you know, it can take a while. So, and it can be pretty expensive and time consuming. And, but that's just kind of a fundamental way to, you know, secure generational wealth. And, you know, with the right estate plan, you can continue to pass that on to your heirs. And so kind of just another rundown of heirs property resolution. Obtaining a title search is huge because, you know, some people can say, oh, they think they know who owns the property, but without a title search, I mean, you're not going to know for sure. And so it's best to do that. And then once you've got that, then you can determine the names, dates of death, status of probate for any deceased heirs. Then you got to figure out all the living heirs and understanding the client's goal. I mean, that obviously that comes at the beginning of the process, but sometimes, at least what I've noticed is that when people see that clear title is in sight, they might get some more ideas on, you know, what they can do with the property, and they're more aware of good programs, you know, like the Longleaf Alliance and other organizations that might be able to help them once their title is clear. And so their goals might shift, you know, and but it's just important to be aware of those, and then determining the appropriate legal strategy based on the goal. So those legal strategies might include, you know, as I kind of mentioned, probating estates, drafting and executing quitclaim deeds. It might be drafting powers of attorney, tenancy agreements, land agreements, quiet title litigation, partition actions, or LLCs and trusts. And so working with the center, there's kind of a, you know, it's similar to the questions before, which is, you know, like, what does the deed say? Is the person on the deed living, deceased? You know, how many generations back are they? And then figuring out who has the ownership interest, and, you know, kind of working with the family to identify heirs. And then also which steps are required to clear title. Again, that's probate, deeds, litigation, consolidation. And then how can heirs property be prevented? And that's when we say estate planning, estate planning, estate planning, estate planning. So speaking of estate planning, let's get into that. Heirs property prevention. So one method is to have property ownership as joint tenants with rights of survivorship. So if you've never heard of joint tenants with rights of survivorship, basically an example is, like, say you have 4 people who own the property, like, okay, let's say mom, dad, Bill, and Ann. Let's say mom dies, and then that her interest goes and splits between the remaining 3. Then dad dies, and then his interest splits between the remaining 2, and they all kind of consolidate down. And so let's say, I think I said maybe Ann dies and Bill's left. So then all of a sudden the title is all in Bill's name. And that's great. But to kind of get into the next part is that Bill should really have an estate plan, because if he dies, where does his property go? You know, it'll probably go to his heirs. And so it's really important to have a will directing how the property should be distributed. Bill could leave it to a single beneficiary. He could instruct his executor to sell the property and divide the proceeds between beneficiaries. He could give family members the option to purchase the property. He could instruct the executor to divide the property among the beneficiaries. And then he could also place the property into an LLC or a trust. But I will also say with LLCs, it's still important to make sure that your LLC interest is accounted for in your estate plan, because if you die, then you have to, you know, somebody has to figure out what to do with your interest, and that can create an issue as well. And so what is estate planning? So kind of basic definition of an estate is that it's all the real property and other possessions that belong to a deceased individual. Estate planning is the process of anticipating and planning what will happen to you and your assets when you die or become incapacitated. So, you know, nobody likes to think about it. I know it's kind of a dismal thing to think about, oh, what happens if I die? But the truth is, you know, you kind of have to consider, you know, how right now, how will you hold the title to your property? But then who will inherit your assets after you die? Who will make those healthcare decisions? You know, if something were to happen to you and you're unable to make those decisions or even make financial decisions? Who is going to take care of you? And then who will manage your assets? I guess that's kind of the same thing that I was saying. It's, who's going to help out if something happens to you, and like who's a trusted person in your family or even a friend that you might rely on if something bad happens. And so a complete estate plan consists of an advanced directive for healthcare, a financial power of attorney, that last will and testament, and then it might also include any nominations for guardians or conservators if you have, say, a minor child that might need taken care of when you're gone, or if you have an adult in your life that needs taken care of, that you're, their caretaker. And then there's also trusts, and there's several different types of trusts that an estate plan might include. And so why do you need a will? If you haven't heard, I don't know, I feel like will might be one of the buzzwords of this presentation, but basically having a will ensures that the testator's wishes are carried out exactly as he or she wants them by their chosen executor. And it also allows the testator the opportunity to leave their real property in a way that doesn't increase heirs' property. And then it also allows them to choose someone trustworthy to take care of minor children. That's kind of that guardianship sort of thing that I was talking about on the last slide. And then it protects the financial interests of the testator's family, especially surviving spouses and those minor children. It allows the family to be part of the decision-making process as the will is prepared. It also gives the family members time to grieve without having to argue with lawyers and each other over what the testator would have wanted or who would become the guardian of minor children. Again, this is just stuff that I've seen not only in my family, but other families. Somebody dies, there isn't a will, and it just, people you thought always got along, it was just, always a great relationship. Then if there wasn't a will already lining up what was going to happen, people were at odds, and it's just so fast. And I think it's part of, grief processing and different things like that, but it can be really complicated if there isn't a will involved or some written document saying, this is what I want to do with my property. So in the state of Georgia, when someone dies without a will, well, anywhere it's called dying intestate. But when you die intestate in the state of Georgia, it basically means that the code dictates who inherits from your estate. And that means that a probate judge is going to decide a lot of things. They're going to decide who becomes the administrator of your estate. That may or may not be somebody that you would have trusted when you were living. The probate judge will decide who becomes the guardian of your minor children or an incapacitated adult heir. And if you own any real property, as you saw in those bubbles from earlier, it'll just become heirs' property. It happened really fast. Like, mom died without a will, and then all of a sudden 5 people own the property jointly. So individuals who own an interest in heirs' property still benefit from will drafting, as generations continue to pass away. If you have a will, it can kind of make sure that it doesn't keep fractionating out, essentially. So you don't need to wait until you until the heirs' property is resolved to have an estate plan. And a will might help as kind of a stopgap, but it's not a permanent solution. The main thing is to fix the heirs' property issue, because that still needs addressed. That's the larger problem. And then once title is clear, or once something else happens with the property, you should really revisit the will and make sure, to amend it or do a new one in any way that reflects that the title is clear to the property. And so safeguarding your documents, original documents should be stored in a safe and accessible place. I will say, few years before coming to the center, I actually worked at an estate planning law firm. And one of the things that we would get was people would come through the door and be like, I'm the executor of this estate, but I can't find, the person who died had a safe deposit box. But there's, the executor didn't have access to it. They couldn't find the key. No one knows how to get to it. So then how do you obtain the will? How do you do that? And so you really need to make sure that, maybe your executor knows, first of all, that they're going to be the executor of your estate. And then also make sure that they have access. But again, this is also, really banking on how much you trust that person, and that they're going to do right by you, and you have to make sure that they have access to your documents. And then make sure that you don't write on your will or cross out any sections or words or make changes in writing on the original document, because that might invalidate the document. This kind of goes back to what I was saying on the last slide, which is that a will, like if there's a change in the property that you own, or if there's something else that you left out of your will or something, don't just scribble it in. Actually go and either get an amendment to your will or get a whole new will that voids your old one. So just make sure that you have a fresh document that reflects all of those changes, because you don't want any kind of mix-ups on what you had, or you don't want a court interpreting what your wishes were because of some scribbles or X marks that you put on your will. So attorneys, I just want to emphasize this, attorneys are essential. I know that it can be kind of intimidating. I know that there are some people who have really been unfortunately traumatized by working with some attorneys, or maybe overcharged. But for these types of things, attorneys are really essential for handling heirs property cases and ensuring a proper estate plan. Heirs property cases are often pretty complex, and so you need some expert level property law knowledge, but also even just kind of mediation expertise, because again, you're dealing with some families who have been impacted by heirs property for sometimes generations. And so you have to really have some skill to deal with that. And then estate plans completed without a trusted attorney, and an attorney who knows how to not make heirs property, can create heirs property and lose the generational wealth that your family has been working to build. And so again, just to kind of emphasize, you really need to speak to a trusted attorney, because having a will doesn't mean that you won't create heirs property. But having a will that doesn't leave real property to more than one person is the best way to prevent heirs property. And, really everyone needs to consider heirs property when they're drafting their will, even if you might own real property, but even if you don't, or even if you know that some might be coming your way, or even if you have a super teeny tiny interest in the real property, you should have a will that doesn't create heirs property in some way. So now we're gonna start wrapping things up, and I know at the end of this we'll have some time for questions. So we kind of have some different resources on our website that are available to the public. Basically, we have a estate planning handbook for communities. That will kind of run through some of the stuff that we've talked about today. Myths and facts, also very similar to the ones that I talked about earlier. There are some brochures about heirs property and estate planning, which is kind of some basics. There's a disaster mitigation planning handout and checklist. And I will say, with the different storms that blow through, tornadoes and different things, I think it's pretty important to look over that one. And then there are webinars similar to this one that you can look at. And then also we contract with different communities to do educational outreach similar to this presentation. And we assess the condition of titles, and then we'll provide title clearing and estate planning services to those communities. And let me emphasize that that's funded work, y'all. So And then also another resource that we just like to share with people. We don't, have any specific partnership going here, but this is just something. I don't remember what that acronym stands for, GSCCCA. It's so long, but I know that it's a filing activity notification system, and it's offered by the clerks of the superior courts here in Georgia. And it basically allows you to receive notifications for when real estate or personal property records are filed, indexed, or transmitted through those clerks. And, kind of like some of the stuff we were talking about with developers or other people, who you don't know might try to file some things on your property. And I know there's kind of an issue with some real estate fraud going on. So if you really want to protect your property from any unauthorized filings, I would suggest going to this website and creating your account. It's a free account, so I think that's really a good benefit. And then this slide is just kind of our a little call out to this program that we have with the Longleaf Alliance, where we're trying to increase the opportunities for Georgia forest landowners through property rights. So, if you ask yourself these questions, is your land heirs property? Do you need help clearing title? Do you need an estate plan? Do you want to get the most out of any USDA, state, local, regional programs? Do you want to unlock the economic opportunities your land can provide? And if you answer yes to these questions, then you can give us a call at 706-424-7557, extension 1. You'll get our lovely intake coordinator. She's such a nice lady. And, perhaps we can help you with your heirs property issue or get your estate plan sorted out. So now I think we are to the question.
Okay, I'd like to add one thing.
Yeah.
That is that in the chat, I'm noticing that a lot of people are not from Georgia. And I just want to say this is Georgia specific, and that we are not speaking to the laws in the other states because we don't know them. And we're only licensed to practice in Georgia. There was one question in the chat. What is clear title? And clear title, it's a very good question. And actually, I think we'll probably amend our presentation to have a definition. And I think we sort of talked around it, and perhaps the definition was there, but it might have been a little bit too hidden. Anyway, clear title is where you have the ability to use the title to the property for whatever manner you want. And usually that means it has to be at least in all living people's names. And if it was in a group of people's names and it's tenants in common, then you would have to have some kind of legal agreement among all the tenants in common as to how you were going to use that property and operate. Marketable, and also or else in one person's name or in an entity. And I'm not even sure that I would group like 5 family members all on the deed together as clear title. It would depend on the title insurance company and what it is that they would require in order for you to have insurable title. And usually it is a requirement that there be one person or one entity in control of the property. By entity, I mean LLC or trust. And the other part of that is that there's also marketable title, which is just a little bit stepped down from a clear title of insurable title, but it's marketable and that you would be able to sell it and you have the legal right to convey your interest in the property to another entity for either, or another person or entity for selling it or for borrowing money on it or anything that you want to do legally with the property. Any other questions?
Yes, that was a great explanation. Thanks, Skipper. So I had one kind of come on in offline, sort of a scenario. So they asked, is there a difference when a group of landowners have a shared interest in a property versus a will that splits the property into equally sized parcels. Is there a difference in addressing those two scenarios, or is there no difference if it is still if that property is still on the public record as one parcel? So I've heard this kind of scenario too, just with folks I know, where sometimes they have had that farm, say it's a 100-acre farm, actually carved out into different pieces for individual heirs to kind of have ownership over. Can you maybe just speak to whether that's just sort of a kind of a fiction, or is there actually a legal difference in how that land was passed?
So we're attorneys. So I'm an attorney. Jasmine did go to law school, but chose not to take the bar. I don't blame her. But it depends. And I would have to see the legal documents, but if the parcel is still held legally in the deed room, that it is one parcel, then it is technically heirs property. It has to be subdivided, surveyed, deeded out among the heirs. There has to be a legal record, because when you do a title search, you're going to see who actually legally owns that property.
Okay, gotcha. Yeah, and just another reason to understand where your property's held before you pass it on. There was another one that came in kind of from the beginning of the talk. I think Skipper, you did address it, but let me just make sure. You mentioned at the beginning a lot of the programs that are not available to heirs property owners, conservation easements, loans and lending, cost share programs, natural disaster relief, kind of went on. I think you did explain it later on that a clear title is required for any of those programs or assistance. Is there any more reason behind that or history behind that clear title requirement?
I haven't really studied the history of it. I've studied the problems with it. And but you have to think of, if you go to the bank and you want to borrow money, they're going to want to know that you have a collateral. And it's not really that much different when you're working with other folks. When you're selling timber on your property, for example, if you don't outright own it, then you're creating some liability issues when you start selling the timber. And there may be some shady folks out there who will give you a lower price because they know they're taking a risk. But it interferes with your ability to do anything up and up, because you actually own that property with a lot of different people. And the government programs have typically treated it similar to what the requirements are for a loan, and that they want to make sure that that public subsidy goes into the right hands, and that they are not also setting themselves up for any long-term liability for an heir coming along and saying, wait a second, why did they get money and I didn't? I mean, it's all the business of owning property.
And another kind of a comment, but this area of the law is very specific. So landowner would need to seek out an attorney who is very familiar with laws of estate planning in the state where the property exists. Is that right?
That is correct. Furthermore, I would recommend seeking out an attorney that is familiar with heirs property, so that you don't accidentally create heirs property in your estate plan.
And the more education, the better, so that sometimes it's probably the client bringing those concerns up and that need to make sure they're doing it right. Good to know. Yes, you had mentioned too, Jasmine had kind of mentioned a couple things I was going to touch on at the end here, so thanks for doing that. But yes, the Longleaf Alliance and the Georgia Heirs Property Law Center are partnering across Georgia to do some education for landowners to address these concerns, do better planning. Like I said, like I say in some of our flyers, it's really for anyone who is ever going to pass their land on to the next generation. So it kind of is a catch-all for anybody to consider these questions and consider this planning and do some of their own diligence. Through that, we're hoping to make more of those forested acres work for the landowners rather than being a hindrance to that progress, a hindrance to building wealth, create more possibilities for landowners by accessing the true value of their land. Through our partnership too, and yes, it is funded, but we are hopefully able to make some of these services available to many more landowners at little cost or sometimes no cost. But so we do appreciate the opportunity to be able to do that and crisscross the state a bit. I just wanted to thank you both and the entire center for the work that you all do, for joining us on this webinar today and taking a little time out of your Thursday to do this. I think it was really well received from the look at the comments and from our attendees well outside of Georgia as well. So I think this topic really resonates with folks. And for those of you on the call today, there are a couple of resources and links on that webinar landing page, and all of our contact information as well. If you need any help finding the right resources for you, please don't hesitate to reach out. So thank you all, and yep, I'll leave the floor open for Skipper and Jasmine if you want to have any closing words yourselves.
Yeah, I just want to say thanks to Karen and Jacob for helping us, get this put together. It was, kind of a short deal, but we're here, and I think it went really well, and really appreciative for all of the great comments that everyone left and the great questions that y'all had. So thank you.
Yes, thank you. I did want to speak to the comment by someone. Clear title can also pertain to oil, gas, and mineral rights, and you are 100% correct. So just want to acknowledge that is a true statement. Thank you. It's been a joy, and it's always great to share the information.
Both, and thanks everyone for joining us. Have a great day, and hope we'll see you on another one of these again soon.